All right, so today I'm going to be answering the question of whether or not you should give a recorded statement to the other side's insurance company. So a lot of times people get into car accidents and the other insurance company calls them up, just really hustles them to try and get a recorded statement. Calls right away, hey, how are you feeling? What's going on? Would you mind giving a recorded statement so that we can hopefully, resolve this claim right away? And people usually say, yeah, sure, I'll give a statement. Why not? Okay, big mistake. My number one tip when giving a recorded statement is not to give a recorded statement. The reason being, there's many reasons, but essentially the insurance company has one goal in mind: to pay as little as possible on your claim. Whether it's their insurance, whether it's your insurance, whether it's pretty much any auto insurance, they don't want to pay. They don't want to pay unless they have to. So you don't want to give a recorded statement. The adjusters are very trained, very skilled to ask just the right questions in order to make it seem like you're not as hurt as you are. And you might not even know the true extent of your injuries because many reasons. You might not have gotten checked out yet. You don't know your diagnoses. You don't know what medical bills you're going to have in the future. So just best not to give a recorded statement. But if you happen to give a recorded statement, then I'm going to give you a few tips to go for so that you can at least minimize your risk. So basically, you want to talk about, they're going to ask you about the accident. You'll, be straightforward and honest about how the accident happened. And obviously, you're going to say in a way that is the truth. And I mean, especially it's a lot simpler if it's a rear end accident. You're just sitting at a stoplight and you get rear ended. But let's say it's not. Let's say it's a more complicated accident. Then this is where you might get into trouble because they are going to try and ask questions in a way to try and pin some kind of negligence onto you. And without talking to an attorney first to see what exactly happened in the accident and how to talk about how the accident happened, then it might make it more difficult down the line to dispute what you had said earlier, since now you're kind of locked into a recorded statement. Let's say another issue with it is that you can't exactly say, I don't know, or I don't remember, because let's say the other driver does remember, then their statement is likely going to carry more weight in determining liability and determining, how much negligence they're going to pin onto you. So best thing, again, not to give a recorded statement, but just to be truthful and honest if you do. And because once you say it, it's pretty much going to be, set in stone. Down the line, let's say you do go into litigation, they take your deposition, they're going to have that recorded statement to make sure that you're keeping your story straight. So another thing about your injuries, if they ask you about your injuries, you're not going to want to say, well, I don't really know, I wasn't so hurt, or I'm feeling okay, I'm feeling fine, because you might not know the true extent of your injuries. Maybe it's just the day of the accident or the day after where you have severe whiplash injuries, but you don't really know the true extent of the whiplash injuries. It's a big problem. So best answer is, I really don't know the true extent. I haven't been checked out yet, or I don't know the true extent. I just got checked out, but I'm still feeling stuff and I feel like symptoms are coming on. Whatever the truth is, you just don't want to say that you're feeling fine. Another problem is that they ask you, from a scale of 1 to 10, what kind of pain are you feeling? If you answer a 4 or 5 and the next day you're really feeling it, like a 7 or an 8, then it's going to sound kind of weird when they pin it back to you later saying, oh, well, you just said 4 and 5, and after the accident, after our statement, now you started feeling worse. Like, what's going on here? So it's a problem. Best not to give a recorded statement. Something to keep in mind is that the adjuster is not your friend. The adjuster might try and come off very nice, very casual, wanting to, just be very friendly with you. Maybe sound sympathetic. Say things like, well, I'm so sorry that you got hurt, but thankfully it wasn't serious. And you might want to agree with them, saying, yeah, thankfully it wasn't serious. You just said it wasn't serious. You just said you didn't have a serious injury. It's important to talk to an attorney before giving a recorded statement. I would never, ever recommend someone give a recorded statement without talking to an attorney. Or in larger accidents, just don't give a recorded statement in general. They don't need one. They don't have to have one. They'll be entitled to a deposition in litigation, but at least you'll have an attorney present. They'll be able to say objections. They'll be able to guide you through the process, so that at trial you're gonna minimize your risks. Like, you know, they could just ask you anything, and in a recorded statement, generally speaking, and it's kind of just, you know, being unrepresented with someone very, very skilled to minimize your claim. So hope this was helpful. Don't give the recorded statement, and that's my tip. And let me know what else you guys want to hear, and I look forward to seeing you all soon. Thanks.